Mr. Smith.
My Lord, to pick up with the question that my Lord asked me before the adjournment, there are two places where we see the reasoning for suggesting a 2-year limitation period for wrongful delivery. The first is briefly in the positive recommendations document at 1319, where it is said the subcommittee believed the carrier should not have the benefit of such a short period, i.e. 1 year, in that case, and 2 years would be more appropriate. So not much reasoning, but that there is the headline reason. A little more flesh is put on those particular bones later on in the debate, when the French delegate at the plenary session on, I think, the 11th of June, says at 1309 in the translation, 1291 in the French version of the Travaux, there were two trends. First was we're going to maintain the period of 1 year. You've seen the International Committee has proposed a period of 2 years. Why? Because we're saying that when the recipient receives damaged or incomplete goods, he's fully aware of the claim. But in the case of wrong delivery, the true holder of the bill of lading may not know the actual situation. So the rationale seems to be that a longer period is needed for that reason. Although I ask my lords to note that that longer period begins with the date of the bill of lading in the proposal made by the committee, not the date of discharge or the date of delivery. So it's 2 years from the date of the bill of lading for wrongful delivery claims. So I hope that answers my lord's question.
Thank you.
I had summarised, I hope accurately, the comments made by the various maritime law associations in relation to the report of the subcommittee. The reason I was confident that my summary was accurate was because I was following, I hope reasonably faithfully, a summary given by Mr. Moore on the 10th of June representing the United States, which my lords have at page 1367 of the CMI Travaux. It also appears at 1289, but with a typo. So I'm going to stick to 1367, if I may. Mr. Moore, introducing the proposal, says the Maritime Law Association, at the bottom of the page, of the United States on this point, finds itself in a large majority, which would simplify and clarify the present rule by specifically making the carrier's liability with respect to the goods subject to a limitation as to time, not only as regards loss and damage, but in other respects as well. So the intention is to say, well, it's not just loss and damage, but it's other respects. No intention indicated there to cover a wider period than the period of responsibility. Those who've expressed a preference for maintaining the status quo on those points either have indicated that preference as a choice between the subcommittee proposal for 2 years on claims for wrong delivery and the status quo. So in other words, those that said status quo were really just voting against the 2-year proposal, or they've objected to the drafting. So those who are voting for the status quo didn't like the drafting. And Mr. Moore then goes on to say it appears that a clearly drafted version, providing for a 1-year limitation on a broadened basis, would receive general approval. So that's his conclusion from the comments of the Maritime Law Associations. And we can pick up, if we go back then to page 1290, and I apologise for jostling between the two versions, but it's a consequence of the fact that they don't all have the same detail in. 1290, we can pick up the debates, and my lords, broadly speaking, the translations of 1290 appear at the end of this tab at 1309 and following, which we've already looked at. So Mr. Moore, on the 12th of June, introduces the report to the committee, middle of page 1290. There is some debate, which I don't think we need to go into. It's at page 1290 to 1291, or in the translation, 1308 to 1312.
On these two versions of the Travaux, does one include more than the other, or is one more official than the other? Or?
One is, the one we're looking at is what we've called the Berlinghieri Travaux.
Right.
And what Mr. Berlinghieri has done is to set out each provision as it becomes the Hague-Visby rules. So each article appears and is then followed by a summary of the workings, both for Hague and for Hague Visby, which is why I've taken my lords to this version where we need to. The other version is the CMI, what we've called the CMI version, as published by the International Maritime Committee. That's the version beginning at 1315. I don't believe, apart from the occasional typo, there's any...
The content is the same, so...
The content is the same, but they don't both have the same level of detail. So there is some reference to committee discussions and plenary sessions where you need to look to the Berlinghieri Travo to see the context of what we're reading that's not set out as clearly in the CMI Travo. And I don't believe...
So there's more detail in the Berlinghieri version, is there?
Not always, from what you're saying.
Not always more detail, but by and large the Berlinghieri Travo have got, for example, Malona Jr. just reminds me, has the debates on the 12th and the 14th of June, whereas the CMI Travo tends to have a summary and the discussion at the end, because there are committees, subcommittees, and then reports to the plenary sessions of the conference, which I'm trying, as I go along, to indicate which bit we're looking at. So the work we've looked at so far was the subcommittee that was set up before the conference. The comments of the International Maritime Associations came before the conference. The introduction I've just read from Mr. Moore on behalf of the United States is actually when the committee was considering this issue. On the 12th of June, the conference had opened on the 10th of June. There had obviously been some discussions. Part of the problem is that if we had produced the entire Travo, they run to 2 or 3 lever arch files, nearly all of which was irrelevant, and we've tried to distill what matters, but it's therefore necessary to piece together some bits of the jigsaw. But what we have on the 12th of June, as I said, Mr. Moore, and the added complication is we're about to come across the drafting committee as well, which is essentially a subcommittee of the subcommittee. But Mr. Moore introduces the report of the International Committee to the Committee on Bills of Lading at page 1290. There is then, as I was saying, a discussion of a French proposal that the wording should include express statement that it applies to misdelivery claims. And that goes on over a number of pages, as I've said, in the French and the English translation, culminating in the English translation at 1312, with the chairman pointing out that the wording of the American proposal in fact already includes, is wide enough to include, wrong delivery. That's the middle of page 1312. And there is then a vote on the American proposal, and it is passed. And that proposal, and again I'm afraid we have to go back earlier to see the actual proposal, is at 1290. The American proposal was, quotes, the subcommittee, having fully considered the question of the time limit for claims by cargo owners against carriers, directs the drafting committee to prepare and submit a draft amendment to the 3rd paragraph, Article 3, Rule 6 of the Hague Rules, such amendment to provide a 1-year limitation of time to sue in the broadest possible terms. So the American delegation's proposed resolution reflects what Mr. Moore had said in his opening comments that I took my lords to earlier. That resolution is passed, and the drafting committee goes away, and that afternoon there is a further, we don't see any workings of the drafting committee, but we see their proposal. And the proposal of the drafting committee is at 1295 in the French, translated, and I have to, with some regret, say mistranslated, and this is agreed between the parties at 1313. So there are 2 proposals we see at the top of the page in the French, a majority proposal and a minority suggestion. They are translated, if I just take my lord straight to the translation, at 1313. The first proposal for Article 3, Rule 6, in any case, the carrier will be discharged of any liability, and in the translation the word whatsoever is missing. It's agreed that it's there in the French translation. So, my lords, the word whatsoever needs inserting there. Will be discharged from any liability whatsoever relative to the goods. And then the proposal of the minority is that in any case the carrier and the vessel will be discharged of any liability whatsoever relative to the goods within the scope of the provisions of this convention. And there is then a debate about whether that wording is required. And that debate harks back to the fact that there are still some countries which don't regard misdelivery as being within the ambit of the convention at all. And ultimately the majority view prevails. And is approved by the committee and then put to the plenary session. And just for my lord's note, the vote is at 1296 in the French, 1314 in the translation. And when Mr. Van Rijn introduces the proposal to the plenary session, and again, because we're back in the plenary session, we need to go to the CMI Travo. What Mr. Van Rijn says at 1369, introducing to the plenary session of the conference the wording that has been approved in the committee, in the middle of the page, as regards the third positive recommendation of the International Subcommittee, so that's referring back to the third recommendation, Subcommittee moves an amendment to the present text of the Convention, more exactly to the present text of Article 3 Rule 6. The object of the aforesaid amendment is to give the text a bearing as wide as possible, and this is the reasoning, so as to embody within the scope of application of the 1-year period even the claims grounded on the delivery of the goods to the wrong person, to the person not entitled to them, i.e. even in the case of what we call a wrong delivery. And so there the position rested, that the wording was amended slightly to accommodate the new Article 6 bis, dealing with claims, recourse claims, but the wording that had been approved at the committee was then accepted at the plenary session. And as Mr. Diamond tells us in his article, I don't think we need to turn that up, there was no further consideration of that wording either in 1967 or in 1968. So that is the debate, and in our submission two things are clear. Firstly, when the Convention used wide words to amend the Visby Protocol, it was to ensure that any kind of claim not directly related to a physical loss of or damage to the goods would be caught by the time bar. That wide wording was not intended to apply the time bar outside the period of responsibility. On the contrary, the debates we've looked at in relation to Article 1E and Article 7 show that those involved in the Visby Protocol considered and rejected the possibility of widening the temporal scope of the rules generally. And if they had intended to widen the scope, the temporal scope of Article 3, Rule 6, one would have expected that to be referred to either in the debate about Article 1E and Article 7, or the debate about Article 3, Rule 6, or possibly both. In short, where it was a fundamental part of the compromise represented by the Hague Rules, that the responsibilities, liabilities, rights and immunities should be confined strictly to the contract of carriage, that is to say the periods starting with loading and finishing with discharge, any amendment to that would have been clearly indicated in the Visby Protocol Travo, and it is not. We therefore invite this court to conclude that the Hague Visby Rules time bar, like the Hague Rules time bar, has no application to claims arising after discharge. Moving on, my learned friends say, well, even if that is right, the manner in which the parties have incorporated the Hague Visby Rules into the Bill of Lading indicates that they intended the Hague Visby Rules to apply to the whole period of the Bill of Lading contract. In our respectful submission, that is something of a non sequitur. If we get to this stage, then my lords are, by definition, with me, that the Hague Visby Rules, like the Hague Rules, do not apply outside the period of responsibility, including the time bar. My learned friend's case on this, see, for example, paragraph 188 of their written case, is that the whole of the Hague Visby Rules apply to the period before loading and after discharge as a matter of contractual construction. And in our submission, that cannot be correct for two particularly headline reasons. The first is that the Hague-Visby rules include, as well as the time bar, various exclusions of liability in favour of the carrier, or limitations of liability in favour of the carrier. As Lord Justice Mayles said in the Court of Appeal, paragraph 12 at page 112 of my Lord's bundle, clear words are required to exclude the carrier's liability. And insofar as it is part of my learned friend's case that those provisions of the rules that exclude or limit the carrier's liability are incorporated into the bill of lading contract, it is our submission that the wording is not sufficiently clear. Wording that incorporates the charter party and only at one remove incorporates the Hague-Visby rules generally does not indicate an intention that those rules should apply outside their own period of applicability. More fundamentally, one needs to look at what the bill of lading does in fact say about the period after discharge. And as I've taken my Lords to, and we'll come back to in a moment, Clause 2C of the bill of lading specifically provides for the carrier not to be under any liability in respect of the period after discharge or before loading. My Lords, as I said, took my Lords earlier to Clause 2C at 3340, the carrier shall in no case be responsible for the loss or damage to the cargo, howsoever arising prior to loading or after discharge from the vessel. As well as I've already said, containing provisions that exclude or limit the liability of the carrier, the Hague and Hague-Visby rules contain a package of provisions that create responsibilities and liabilities. So my learned friend's case involves submitting that by their wording, the parties have indicated an intention that the Hague rules or the Hague-Visby rules should apply to the whole period covered by the bill of lading contract, even after, I'll just concentrate on discharge, even after discharge.
Why isn't 2C a complete answer to your claim?
That's a point that I think Lord Justice Mayles put me in the Court of Appeal, and the answer is, on another day, it may well be, but in our submission, it isn't. And it isn't for the reasons that Council accepted in the MSC Amsterdam. And I'm going to come on to mention that in a moment. But it is not apt to exclude liability for delivering to a party that does not...
Although loss and damage in the Hague rules has a wide interpretation, here it has a narrow one, does it? As far as the misdelivery goes.
My Lord, as far as delivering to a person not holding the bill of lading is concerned, yes. And I have to say that for obvious reasons. But in terms of what the wording means, it doesn't affect the situation. Because this wording does not just exclude liability for misdelivery. It excludes any liability. So if I can posit for the purposes of this debate, and I'm going to come back to deal with my Lord's point in the context of Clause 2C more generally, but for the purposes of this debate, were the cargo to suffer wetting damage while it was on the quay because of a failure properly to care for the cargo, the carrier would be able to say, well, I've excluded my liability for allowing the cargo to become wet and therefore physically damaged. But the Hague rules would say, or the Hague-Visby rules would say that they were liable. And that is why we say that Clause 2C negatives any intention to apply the Hague-Visby regime to the period after discharge. And one can pick, as my Lord has done, examples around the edges of that might be more difficult, which is why I've picked an example which we would submit was right in the middle and therefore rather easier from our perspective. But for the purposes of whether they intended the Hague-Visby regime to apply before loading or after discharge, a clause that says we are not liable in respect to that period, an actual written clause in the bill of lading, is wholly inconsistent with saying that incorporating the rules, which in their own wording only apply between loading and discharge, should be expanded as incorporated, and that at this stage is the only point I'm dealing with. So, my Lord, that's express incorporation, but my learned friends have a fallback position, which is implied incorporation, and they rely on the so-called Carver implied term. And I'm going to deal with that very briefly. The Court of Appeal in our submission was right to have doubts about whether that term applied on the facts of this case. That's not to say that the learned authors of the present edition of Carver are not right to say that in certain circumstances a term may be implied that the rules will continue to apply after discharge. Of course, that term may be implied. The question in our respectful submission is whether on the facts of this case it should be implied. We submit that there are 4 key reasons why it should not be. The first is, as Lord Justice Mayall said, there are no findings of fact on which any implied term could be based. The second is, again, as Lord Justice Mayall's observed, it's difficult to imply a term as a matter of law when the rules on their own wording don't apply outside the period of responsibility. The third is that however one formulates a test for implying terms, whether by reference to an officious bystander or otherwise, the implied term contended for doesn't pass muster. If one were to say to an officious bystander who was aware of the existence of Clause 2C that the parties nonetheless should be implied to have agreed that the rules apply after discharge, rather than saying, of course, the officious bystander is much more likely to say, of course not. Look at Clause 2C. Of course they don't intend a package of rights and responsibilities and liabilities to apply after discharge. They've dealt with that in the express terms. And fourthly, as I've said, on the contrary, implying a term in these circumstances is irreconcilably inconsistent with Clause 2C. And, my Lords, that brings me on to Clause 2C. If we are wrong, and the Hague-Visby Rules on their wording, or Article 3, Rule 6 of the Hague-Visby Rules on its wording applies to the period after discharge, it is our submission that the wording of Clause 2C, which I've just looked at, is sufficiently clear to disapply the rules. The starting point is that under Article 7 of the Hague-Visby Rules, which we've looked at in the Hague Rules, and it's the same in the Hague-Visby Rules, there is complete freedom of contract after discharge and before loading. Obviously, we pray that in aid of our headline submission, that the rules don't apply after discharge, but if Article 3, Rule 6 is the exception within the package of rules, then we say that if one looks at Clause...
Well, it disapplies it by meaning that no time limit's appropriate because there's no liability at all in the first place.
Well, indeed, my Lord, and that is essentially what Lord Justice Longmore said in the MSC Amsterdam case. My learned friends don't suggest that that case was wrongly decided. In our submission, it was correctly decided. They seek to distinguish it because in that case, the clause in the MSC Standard Bill, which was sufficient to disapply, in that case, Article 4, Rule 5, rather than Article 3, Rule 6. The wording in that case was significantly wider. And so if I could ask my Lords very briefly to look at the wording in MSC Amsterdam, which is in the core bundle at page 972. The wording of the clause, which Lord Justice Longmore held was effective to disapply the provisions of the rules after discharge, starts at the foot of 972. Clause 4.2 and 3 provide the responsibility of the carrier is limited to that part of the carriage from and during loading onto the vessel up to and including discharge from the vessel. Well, that doesn't say anything more than we get from Clause 2C in our case. and the carrier shall not be liable for loss of or damage to the goods during the period before loading onto and the period after discharging from the vessel. Again, in practical terms, that says no more than we take away from clause 2c. Howsoever such loss and damage may arise, loading and discharge take place when the goods pass the ship's rail or ramp. Again, that adds nothing apart from perhaps a little bit of clarity. Clause 4.3, when the goods are in the custody of the carrier and or his subcontractors before loading and after discharge, whether being forwarded to or from the vessel or whether awaiting shipment, landed or stored or put into hulk or craft belonging to the carrier or pending transshipment, they are in such custody for the risk and account of the merchant. And it's rather a lot more words than clause 2c, but in practice it amounts to no more than clause 2c, saying that no responsibility or liability after discharge. Clause 7 then provided the vessel may commence discharging immediately on arrival without notice to the consignee or any other party. That of course differs from our situation where the charter party had provisions which I took my lords to this morning about discharging in accordance with the carrier's orders, and those provisions would be incorporated into the bill of lading. Again, it goes on to say such discharge shall constitute due delivery of goods under the bill of lading, whether the vessel's tackles or shore cranes or other means be employed in the course of delivery under the quay or otherwise, any loss of or damage to the goods shall, after the end of the Hague Rules period, be at the sole risk of the consignee in every respect whatsoever. And it's correct that Lord Justice Longmore attached significance to the reference, specific reference, to the Hague Rules period. But in our respectful submission, since the Hague Rules period is the period beginning with loading and ending with discharge, again, this provision is in effect wordier, but of no greater import than clause 2c. So we say, in essence, that clause 2c has the same effect, same significance as the clauses we've just looked at in the MSC Amsterdam provision, and therefore has the same effect and consequences that insofar as Article 3 Rule C would otherwise apply after discharge, it does not. And to deal with my Lord Legate's point, at page 974, we see, and this again, to a large extent, deals with the reasoning of Lord Justice Mayles in rejecting my submissions on this point, that in the Trafigura case, paragraph 29, Mr. Parsons accepts, who was for the carrier in that case, that the exclusions contained in these clauses, that's the clauses we've just looked at, do not apply to misdelivery, which occurred in this case, whether such misdelivery is constituted by the wrongful giving of a delivery order to the fraudsters or by the refusal, refusal to hand over the goods on production of the original bill of lading. So if we prevail before my lords, and if this point goes back to the arbitrators, that is the submission I or Mr. Berry, whose case this was originally, will be making to the arbitrators. Clause 2c does not succeed in relation to a claim for misdelivery, but nonetheless the wording of clause 2c is intended to avoid liabilities after discharge and therefore is inconsistent with the Hague-Visby rules applying after discharge either directly or indirectly by implied term, and if they do apply, clause 2c is sufficient to disapply them, as was held by analogy in the MSC Amsterdam. So, my lords, I've taken the last few points at something of a canter, particularly incorporation, but they're responsive to my learned friend's case if I am right, and I may need to come back to those in my reply. And I'm conscious that I've taken the Travo also at something of a canter, but that's because the amount of material that the parties have put in. But unless I can assist my lords further, those are our submissions in support of the appeal.
Thank you very much. Mr. Ramey.
Thank you, my lord. My lord, I propose to take the three issues, the Article 3 Rule 6 issue, the contractual application issue, and the Clause 2c issue in turn. I'm going to start with the Article 3 Rule 6 issue. And like my learned friend, I'm going to take them, first of all, by looking at the Hague Rules, and then by looking at the Hague-Visby Rules. In relation to the Hague Rules, I'm going to consider, first of all, the language and effect of the Article 3, Rule 6 time bar, and to try to derive its scope and purpose from the language used in that time bar provision. Then secondly, I'm going to consider the case that notwithstanding what we say is the width and scope of Article 3, Rule 6 time bar on its own terms, on the true construction of the rules, its application is to be restricted or cut back so as to apply only to the period between loading and discharge and liabilities incurred during that period. And so those two parts effectively track the propositions which are set out in our written case. The Hague Rules time bar, the point I'm going to take first, and its language and scope is Proposition 1, and the restriction which the Court of Appeal have found and for which the appellants argue are my Propositions 3, 4 and 5. So if I start with Article 3, Rule 6 of the Hague Rules, and if I can ask the Court to look at the text of that, which is in the treaty text. The relevant page is in the core volume 1235. It's convenient to consider Article 3, Rule 6 in two ways. First of all, to look at the text of Rule 6 as a whole, of which the time bar forms a part, and then to focus on the time bar separately. And if one looks at Rule 6 as a whole, the Court will immediately notice a number of features. The first important feature is that this rule is unique in the rules, the Hague Rules, in its reference to delivery by the carrier of the goods and to allied post-discharge concepts. So one sees in paragraph 1 the removal of the goods into the custody of the person entitled to delivery thereof, and prima facie evidence of the delivery by the carrier of the goods as described in the bill of lading. One sees in paragraph 2 notice to be given within 3 days of the delivery, and the next paragraph, the notice in writing need not be given if the state of the goods has at the time of their receipt been the subject of joint survey or inspection. We then have paragraph 3, which is the time bar, which refers to 1 year after delivery of the goods. And then in paragraph 4, we have the provision of facilities to each other for inspecting and tallying the goods, which must be taking place between discharge and delivery. And so that's the first feature to note. The second feature to note is that paragraphs 1, 2 and 4, which effectively embrace the time bar in paragraph 3, are regulating and making provision for matters that are to take place between discharge and delivery. So this is a post-discharge provision in our respectful submission. And therefore, the last feature to note is when we come back to the text of the time bar, we see it's playing a part in a provision which is dealing with delivery and the situation in relation to loss and damage, which may be before discharge or maybe after discharge and before delivery.
Well, you think you wouldn't want to have time running before delivery, whoever's right on this point, because it's pretty unfair if you have to. The time for making a claim occurs before you've got the chance to see whether you've got a claim, damage to the goods.
My Lord, I entirely take that point, but when one looks at the whole scheme of Rule 6, and in particular, there were two problems that the Hague Rules wanted to deal with in relation to these sorts of matters. The first was notice of claim and unfair provisions which required the receiver to have to give a notice of claim within 3 or 4 days or lose his rights altogether. It's got nothing to do with the scope of responsibilities or the obligations in relation to carriage. This was something that was a standard feature of bills of lading clauses, and they needed a fair solution. That's what's being dealt with in paragraph 1 The other feature they had to deal with was time bar, and the fact that time bars were inserted in bills of lading to exclude all liability or to discharge the carrier from all liability under the bill after a certain period, usually very, very short. So what we're seeing here are the drafters putting together a composite set of provisions which deal first of all with notices of claim, and secondly with an overall time bar, but with a fair period. And the question for this court is whether, and I'll take the court to some authority which considers the width and expanded construction which this provision should receive, given its purpose in the rules. But the question for this court is whether that width should in some way be cut back. One doesn't find any cutting back or restriction on the scope of this provision in the way it was worded. And so we have two aspects. First of all, we have the paragraph 1, and in comment upon the question my Lord Hamblin was putting to my learned friend this morning, that is a provision which is plainly dealing with matters right up to delivery, because it says that the removal shall be prima facie evidence of the delivery by the carrier of the goods as described in the bill. It's very difficult to read that as being restricted to prima facie evidence of the condition of the goods on discharge. So that is a provision which is perfectly possible, and indeed, in its true construction, can only really be dealing with the whole position right up to delivery. And the position of the carrier as bailee right up to delivery. And in our submission, that's precisely the same for the wide wording of the time bar. The wide wording of the time bar is the carrier of the ship shall be discharged from all liability in respect of loss or damage unless suit is brought within 1 year after the delivery of the goods. And the cases are clear that the words all liability in respect of loss or damage and in any event are to be given the widest possible construction, because they're a time bar provision, the purpose of which is to allow the carrier to clear his books.
Suppose that there's a claim for damage to the goods, and the goods are damaged after discharge but before delivery.
Yes.
And the carrier seeks to exclude liability if no claims made within 3 months. Does that, is that effective, that exclusion?
I'm going to come on to that, my Lord, in relation to Article 3, Rule 8.
Yeah.
There is an issue as to whether that would be possible. Because when one looks at Article 3, Rule 8...
Well, that's what I had in mind, yes.
When one looks at Article 3, Rule 8, which is dealing in rather different terms, it prevents any clause relieving the carrier or the ship from liability for loss or damage to or in connection with goods arising from failure in the duties and obligations provided in this article. Pause there. That will be dealing with the Article 3, Rule 1 and Article 3, Rule 2 obligations, possibly also the obligations in relation to bills of lading.
Yeah.
And then, or lessening such liability otherwise than as is provided in this convention. And the issue there in relation to the time bar would be whether, if this is an absolute time bar that says any claims you have under the bill of lading in respect of the goods are discharged after a year, whether that is tied to the particular operations in Article 3 or Rule 1 or Rule 2, or is an absolute time bar, and therefore cannot be lessened down.
Then you've also got to consider Article 7, haven't
Yes.
you, which seems to give a free right to parties to agree anything they like in relation to period after discharge.
I'm going to come on to Article 7 as well, because one has to read Article 7 in our submission with Article 2, because Article 2 is dealing with a particular set of operations, and Article 7 is saying, in relation to other operations, you can have other clauses. So it's not in our submission necessarily the case that in relation to the time bar, if it has the meaning that we say it has, that one can contract out of that.
So what is your position, that you can't contract out of?
Well, we would say that you can't contract out of it.
I've probably taken you out of order, but presumably you'll develop that at some point.
I will, my lord.
Yeah.
I was just developing the point that Article 3, Rule 6 and the time bar is very widely worded. And we've looked at the position of paragraph 3 in Rule 6 as a whole. Now I just want to focus on the words in the time bar itself. And one has the words in the event and the words all liability in respect of loss or damage. And an important aspect in our submission in assessing whether Article 3, Rule 6 is in some way constrained by the specific cargo operations listed in Article 2 is that the decided cases in this jurisdiction, but not in Malaysia, reject the idea that Article 3, Rule 6 as a time bar only operates in relation to to breaches of the Hague Rules and the obligations in Article 3, Rule 1 and Article 3, Rule 2. So the cases are already, in this jurisdiction, have already established that the Article 3, Rule 6 time bar applies to any liabilities. They're not tied to liabilities for breaches of the obligations in the rules. And one can see that most clearly in the decision of Mr. Foxton, QC as he was, in the Al-Hani. And if I can take the court to that, it's in the core volume at page 542. And as the court knows from this morning, this is a misdelivery case where misdelivery was coincident with discharge. And if I can pick it up in Mr. Foxton's judgment at page 554. Now, of course, he didn't have to consider the temporal point, which this court is considering, but what this judgment is useful for is unpacking the width of Article 3, Rule 6 as a provision on its own. And so, if I can pick it up at paragraph 41, I'll address the issues raised by both counsel under the following headings. 1, approached purely by reference to its language and purpose, is Article 3, Rule 6 capable of applying to misdelivery claims? Pause there, my lord. If it is, then one has to find a restriction elsewhere for cutting it back. And that's the Article 2 point, effectively, which I'm going to do. And then 2, is Article 3, Rule 6 limited in its application to breaches of the Hague Rules obligations? And pausing there, my lord, that's going to be important when one comes to look at the so-called international consensus cases on the Hague Rules, because they regard as a central plank of their reasoning that the time bar only applies to breach of the Hague Rules obligations. And that's rejected also by Mr. Foxton in this decision, correctly, because following the Captain Gregos. So if I can then go on to deal with that first question, approached purely by reference to its language and purpose, is Article 3, Rule 6 capable of applying to misdelivery claims? In my view, the answer to this question is clearly yes. The words in any event are wide, and in the context of Article 4, Rule 5 of the Hague Rules, the courts have emphasised their width and rejected arguments that they're insufficient to apply to particular types of breach. And then Mr. Foxton cites Lord Justice Tuckey in an Article 4, Rule 5 case I have to accept. And there is a difference between the French text. In Article 3, Rule 6, it's en tout cas, and in Article 4, Rule 5, it's en aucun cas. But nevertheless, Mr. Foxton applied it. I think the words in any event mean what they say. They are limited in scope, and I can see no reason for giving them anything other than their natural meaning. A limitation of liability is different in character from an exception. And then he goes on to cite the Petco Voivode case, which we've cited in our written case, and the MSC Amsterdam. And then he turns to the words all liability at the bottom of page 556, paragraph 46. The words "all liability" are equally wide. In a contractual provision clearly modelled on the Hague Rules, Lord Wilberforce in the New York Star, and I'll take the court to that, described the words as general, all-embracing. Taken together, the words "in any event" and "all liability" in respect of loss or damage are clearly wide enough to encompass liability for delivering the goods to someone not entitled to take the delivery of the same. So, again, the question for this court is, that being the case, in relation to the language of Article 3, Rule 6, where is the restriction elsewhere in the rules that says it's to be cut back only to misdelivery occurring between loading and discharge? If I can just go on, because there's some useful passages as to the purposes of these rules. Paragraph 47, in the Captain Gregos, albeit when considering Article 3, Rule 6 in the Hague Visby Rules, Lord Justice Bingham stressed the words "in any event" and "all liability" when finding that the time bar applied to theft of the cargo by the ship owner, stating that he could not see how any draftsman could use more emphatic language. So that actually is helpful in relation to the language which this court is actually concerned with, which is Article 3, Rule 6 of the Hague Visby Rules, being even more emphatic than the language Lord Wilberforce considered all-embracing in the New York Star, i.e. that of the Hague Rules. 48. The object of finality, which it has been held that Article 3, Rule 6 was intended to achieve, in the authorities referred to in paragraph 33 above, I can just ask the court to turn back to page 553, where the court is referring back to the argument of Mr. Phillips in support of an expansive construction of Article 3, Rule 6, supported by the purpose of the rule being to enable the ship owner to close its books, and that's the Aries.
But isn't that, I mean, that's true of any limitation period, isn't it?
It is, my lord, yeah.
But the real purpose of this was to set a minimum period, so the ship owner could not, or carrier could not specify a lesser period than a year.
Correct.
Isn't that the real purpose of this, not closing the books? Because, as I say, that's true of any limitation period.
Well, my lord, that has some force, but in our submission, what the cases are stressing is, because of the language which is used in phrasing this particular time bar.
Well, I appreciate that, but Mr. Foxton is addressing, he says he's addressing not only the wording, but also the context and purpose.
Yes.
Now, what I'm querying is whether this really is the purpose of 3, 6.
Well, my lord,
I mean, we've seen the Trevor. We know what lies behind it.
yes, my lord, the purpose of 3.6 was to provide the carrier with a complete discharge from liability. That was one purpose. The other purpose was to impose upon the carrier a generous period for the cargo owner of 1 year. So it had those two purposes. It was always intended to allow the carrier to clear his books, but because the carrier had been clearing his books by reference to 30-day periods or 60-day periods, the carrier accepted as part of the package that he would not seek to clear his books for a year.
Well, that's where we will hear your argument on Article 7 in due course.
Yes.
So that clearly has a bearing on
It
this.
does have a bearing role, yes. And so he, paragraph 49, I note from the judgment of Judge Diamond, a noted expert on the Hague and Hague Visby rules in the Lenny, there were a number of objectives which Article 3, Rule 6 sought to achieve. First, to speed up the settlement of claims and to provide the carriers with some protection against stale and therefore unverifiable claims. Second, to achieve international uniformity in relation to prescription periods. Third, to prevent carriers from relying on notice of claim provisions as an absolute bar to proceedings or from inserting clauses in their bills of lading requiring proceedings to be issued within short periods of less than 1 year. After 1924, the only effect of the carefully negotiated and complex notice of claim provision would concern the burden of proof. The time for suit provision would replace and standardise the clauses previously contained in carriers' bills of lading. And again, that purpose needs to be borne in mind, because were the carriers contemplating that the time for suit provision would be a split regime, or would be one regime. And then just to finish that sentence from that passage from Mr. Foxton's judgment, while the Article 3 Rule 6 time bar has come to be seen as a provision benefiting the shipowner, this was not the position when the Hague Rules were agreed. As Professor Sturley noted, the time for suit provisions were the cargo interests' other big victory at the Hague Conference, their effect being seen as guaranteeing a claimant a full year in which to bring suit. And Mr. Kenny's submission would reduce the scope of that gain, and that will be relevant, my Lord, to the Article 7 and Article 3 Rule 8 point, which my Lord Legate was putting to me earlier. That's in relation to scope. Then Mr. Foxton went on to deal with the second question, which is Article 3 Rule 6 limited in its application to breaches of the Hague Rules? And he summarises Mr. Kenny's argument at paragraph 51, and that argument is rejected at paragraph 61 and paragraph 65. 61 is on page 560 of the core volume, and paragraph 65 is on page 561. So, my Lord, pausing there, based on the words "in any event" and "all liability in respect of loss or damage," one has a time bar provision which is drafted, which is all-encompassing and all-embracing, and which is not tied to breaches of the Hague Rules. So again, one has to look outside Article 3, Rule 6 for what is supposed to be cutting it down to apply only to liabilities between loading and discharge. You don't get that out of the language. Both Mr. Foxton in the Al-Hani and Lord Justice Bingham in the Captain Gregos placed reliance upon the analysis of a similar clause, as we've just seen modelled on the Hague Rules, in the New York Star. And I'd like to take the court to that, which is at the core volume at page 805. Right at the bottom of the page, Mr. Hobhouse's argument about repudiatory breach and how he would construe the clause. Going over the page 806, Lord Wilberforce for the Privy Council Board, citing the clause itself, clause 17, which the court will see is in identical terms to Article 3, Rule 6. The first sentence of it. A general and all-embracing terms are Lord Wilberforce's words. And then these words, the reference to delivery of the goods shows clearly that the clause is directed towards the carrier's obligations as bailee of the goods. And pausing there, my Lord, we would echo that both in relation to paragraph 3 of Article 3, Rule 6 and paragraph 1. It cannot be supposed that it admits of a distinction between obligations in contract and liability in tort. All liability means what it says. And those words in our submission and that approach to it being an all-embracing time bar clause are important. The wording of Article 3, Rule 6 goes on. So we've had it in any event, all liability. The next words are all liability in respect of loss or damage. And two cases consider the width of that phraseology, the O.T. Sonia and the Sophie J. And if I can take the court to the O.T. Sonia, which is at page 502 in the core volume. You were shown this decision this morning. There were two issues in the case, as we see at page 504, left-hand column. The first is as to the width of the words loss or damage when used in Article 3, Rule 6. And the second does the time limit operate where the goods to which the loss or damage relates have never been loaded
Right, I'm
onto the
awfully
vessel?
sorry. Where are you reading?
So sorry, my Lord, page 504.
504, sorry.
I do apologise, my Lord. 504, left-hand column.
Yes, sorry. Got
Sorry, my
it.
Lord. Two issues of principle.
Yes.
So the second issue, if the latter, does the time limit operate where the goods to which the loss or damage relates have never been loaded onto the vessel? Now, my Lord, this is important because if Article 3, Rule 6 is to be given this restriction, then the restriction has to be linked either to the time when loading commences, however broad you describe loading, and has to end at the time when discharge, however broadly you describe it, ends. The OT Sonia was a case where loading never began. And one sees that because Lord Justice Hurst deals with the answer to the first question, and then the next paragraph, on the other hand, the answer to the second question only affects a small part of the claim, which concerns cargo destined for loading on the vessel, but allegedly diverted to another vessel due to the alleged delay in the start of loading. So this case concerns cargo which was never loaded, was never being loaded, might have been intended to be loaded, but could have been sitting in a warehouse or in another barge going somewhere else. And nevertheless, the time bar was applied to it, and one sees the reasoning for that. Just pausing over page 510, where Lord Justice Hurst again emphasises a wide construction of Article 3, Rule 6 being
Where
urged.
do we see this 510?
510, my Lord.
Whereabout?
Left-hand column. The judge emphasises the need to give it a wide construction to achieve the objective of the purpose of the limitation clause.
So just which bit of it are you reading at the
Sorry,
moment?
It's
Furthermore,
Or are you paraphrasing?
no, the wider construction was fully in accordance
I
with
see.
Mr. Hamden submitted
Yes.
with the purpose of the limitation clause, which, like any time bar, my Lord Richard's point, is intended to achieve finality per Lord Justice Bingham in the Captain Gregos. The wide construction would to a very great extent achieve the objective, whereas a narrow interpretation would lead to a split regime in a very large number of typical cases. And so he then deals with that second issue with that wide construction purpose in mind at page 511. And there's no issue here that the time bar can't apply because the goods weren't being loaded. The court approaches it in a different way, not assuming Article 3, Rule 6 is temporarily restricted, where, as is alleged here, I'm reading from the second column, just after the citation, where, as is alleged here, goods destined for the vessel were not loaded due to the delay, it seems to me that any resulting loss or damage is in relation to goods, seeing that it arises in relation to the loading, handling, stowage, carriage, custody, care and discharge of such goods. So that's not actually linking it to loading, but because they are goods which will eventually be loaded, whether sitting in a warehouse or in a barge or anywhere else. And that could apply equally, therefore, to goods which have been discharged just as well, because what has to be right for discharge and post-discharge must also be right for preloading. And it was that understanding of the decision of the OT Sonia which Mr. Justice Tomlinson considered in the Sophie J, which is in the core volume, page 701. Starts at page 694. If I can ask you to turn, please, to 69, to page 700. the argument which was being put to Mr. Justice Tomlinson was being put by Mr. Matthews for the claimants. So he was arguing for the application of Article 3, Rule 6 on the particular facts of this case. And at the bottom of page 700, just after letter J, he submitted the OT Sonia was binding authority for the propositions that the meaning of the words loss or damage in Article 3, Rule 6 was to be harmonised with the established meaning of those words in Article 4, Rule 2, that a wide rather than a narrow construction should be given to the ambit of Article 3, Rule 6, that the words are apt to cover goods which are intended to be loaded even though they are never loaded, and particularly that the time bar can operate even in respect of an incident prior to loading, so outside the so-called period of responsibility. And it was in that context that Mr. Justice Tomlinson, at the next paragraph, paragraph 15 on page 701, said, in my judgment, the decision of the OT Sonia is not determined to the present application because of the facts as he came on to consider them. I entirely accept, indeed I'm bound to do so, that the words in Article 3, Rule 6 are apt to cover goods which, although intended to be loaded, are in fact never loaded, from which it necessarily follows that the words must likewise be capable of an application to a claim in respect of events occurring before loading begins. And then he has to go on to consider a different point. And in our submission, those two cases do not sit very happily with the submission that the time bar can only apply once loading, however broadly defined, has begun, and will cease to apply once discharge, however broadly defined, comes to an end.
It's my fault, but can I just ask a quick question? On the OT Sonia, page 511, in the passage you showed us.
I'm just turning back to it.
Yes.
Yes, my lord.
Quoting something, manifestly quotes in relation to goods. I was just trying to see where that quote is taken from. Can you help me to understand that?
Yes, my lord. I think it must come from Pyrene and Cyndia, my lord, and the decision of Mr. Justice Devlin in that case.
Thank you.
My lord, lastly, on the width of Article 3, Rule 6, can I take the court to the Aries, which is in the core volume at page 462. This is the source of the clear the books reference, and in the speech of Lord Wilberforce, 462, starting at C, the contract contemplates the possibility of a cross-claim by the charterers in respect of loss or damage to the cargo. It expressly provides by incorporation of Article 3, Rule 6 of the Hague Rules that the carrier and the ship shall be discharged unless suit is brought within 1 year after the date of delivery or the date when delivery should have been made. This amounts to a time bar created by contract, but, and I do not think that sufficient recognition to this has been given in the courts below, it is a time bar of a special kind, one which extinguishes the claim. And then he goes on to deal with the arguments in that case about whether the charterer's claim could be characterised as a defence or a cross-action or a set-off between E and F. And he ends up by saying that at G, I would add that this is unnecessary since the provision is clear in its terms, but to provide for the discharge of these claims after 12 months meets an obvious commercial need, namely to allow the ship owners after that period to clear their books. So, my Lord, just on that first part of my submissions in relation to Article 3, Rule 6, the text is clear and all-embracing. First point. Second point, the text is to be construed expansively in the light of its context and purpose. Thirdly, the meaning of Article 3, Rule 6 and its purpose really has to be gleaned from the language, because it wasn't really discussed. It seems to be taken as self-evident in the Travo. Well, I'll perhaps just take the court to one passage, which we refer to in our written case, which is in the core volume at page 1286. And this is about as much as one gets in relation to Article 3, Rule 6. You have the text set out of Article 3 on the top of the page. And then Lord Phillimore says, we're not passing an Act of Parliament or a bill. As I understand, we're merely incorporating clauses in a Bill of Lading. That's how it was then contemplated. I rather doubt whether the courts will pay attention to limitation of liability in the way of time that we put in the Bill of Lading. This last clause, and the ship shall be discharged from all liability in respect of loss or damage, seems to me to be legislation. At any rate, I think it ought to be expressed in some other way. It looks as if we're making a special statutory limitation in the case of this kind. As a lawyer, it strikes me this is rather an infringement upon the powers of the legislature, or might be construed in this way in some countries. I think it ought to be put in some quite different way, I have not thought how, to show that it is a contract by the shipper that he will not sue after 12 months. I think the real way to put it is something of this sort, and the consignee undertakes to make no claim unless he brings it within 12 months, something of that kind. I've not thought it out, but I think there are objections to it as it stands. And that is very slight, but in our submission does support that what people were talking about was something that stops all suit after a year. So, my Lord, to conclude on that first part of our case, Article 3, Rule 6 as drafted and as inserted in these rules for the purpose for which it was inserted, together with the other provisions in relation to delivery and notice of claim, is perfectly apt to cover misdelivery occurring after discharge, and perfectly apt to cover all liabilities of the carrier as a bailee under the Bill of Lading. In those circumstances, the restriction on the applicability of Article 3, Rule 6 to matters on and after loading and up to and on discharge must be found in other express provisions in the rules. But otherwise, one's left with the wide language and the purpose of clearing the books, and one would expect it to apply, just like the notice of claim provision in the first paragraph of Article 3, Rule 6, to carriers' liabilities, whether within the strict period of responsibility under the bill, or as a bailee before or after. And that brings me on then to the second part of my submissions on the Hague Rules, which is the restriction, or the alleged restriction, or the contended for restriction on the scope of Article 3, Rule 6 by reference to other provisions of the Hague Rules. And the proposition which this court is having to consider is summarised in the Court of Appeal's decision at paragraph 49, and perhaps I can ask the court to turn that up. It's in key documents at page 120. And one sees at page 119, just turn back to that, the court refers to certain provisions in Article 1 and to Article 2. And then at paragraph 49, if, as I would hold, so we pick it up paragraph 48, according the rules do not apply to misdelivery of cargo stored on land after discharge, whether or not such misdelivery is a breach of the contract evidenced by the Bill of Lading, at least where the misdelivery is not related to the discharge operation. If, as I would hold, this is the effect of the rules in general, then the question then arises whether there's anything in Article 3, Rule 6 itself to demonstrate that the time bar was intended to apply to claims for breaches of duty outside the scope of the rules. While it can be said that misdelivery after discharge gives rise to a liability in respect of loss or damage, the words used in Article 3, Rule 6, and that the opening words in any event are wide in their scope, in my judgment, the better view on balance is that there is not. Article 3, Rule 6 is a part of the rules to which the contract is made subject by Article 2. Logically, its application cannot extend beyond the scope of the rules themselves as defined by Articles 1 and 2. In the original rules, at any rate, Article 3, Rule 6 is not a cuckoo in the nest. And then at paragraph 50, the court gave effect to the very wide words, and he cites, Lord Justice Mail cites the cases I've been citing this afternoon, and says, I would hold that the natural meaning of Article 3, Rule 6 of the rules is that if suit is not brought in time, the carrier will be discharged from all liability of any kind arising during the Hague period of responsibility. So the restriction on the scope of Article 3, Rule 6 as a matter of construction of this international convention is to be found, if it's to be found anywhere, both on the Court of Appeal's reasoning and on the appellant's case, in Article 1 and the definitions in Article 1 and Article 2. My Lord, we submit that that construction is wrong for three reasons. First of all, it fails to construe Article 1 and Article 2 correctly and misunderstands the scheme of the rules. It effectively corresponds to our Proposition 4 in our written case. Secondly, it ignores those provisions of the Hague Rules which self-evidently are addressing the situation before loading and after discharge, our Proposition 5. And thirdly and lastly, it fails to take into account important problems which result from restricting Article 3, Rule 6 in this way, which make it unlikely that the parties to the Hague Rules would have intended this split regime, given the time bar's wide terms, our Proposition 6. Can I deal with the first of those matters and the failure correctly to construe Articles 1 and 2. And this is simply an exercise of treaty interpretation to be carried out in the usual way in accordance with the principles set out, for example, in Article 31 of the Vienna Convention, ordinary meaning of the text in light of context and purpose. And if we start with Article 1, the first observation to make, perhaps I need to take the court back to the text now. We go back in the core volume to page 1233. I'll start with Article 1 and then I'll consider Article 2. The first observation to make in Article 1 is that it's simply a definition section. In this convention, the following words are employed with the meaning set out below. So this cannot define a scope of the rules unless there's some operative provision of the rules which, using one of those definitions or one or more of those definitions, actually creates the restriction. And that's something which in our submission the Court of Appeal slightly lost sight of in its focus on what the definitions themselves say, because it's where the definitions are used and how they are used, which is the only way in which the restriction as a matter of interpretation of the treaty text can arise. So what we have in our submission, what one has to do is to go to a relevant substantive provision of the Convention, and the only one in play is Article 2, and see what it says using those definitions. Two definitions were relied upon by the Court of Appeal and are relied upon by appellants. First of all, 1B, contract of carriage. And it's important just to stand back a little bit and look at the whole of 1B to see what it's doing, because this was a convention which was to regulate bills of lading and nothing else. So there are three aspects to Article 1B. Contract of carriage applies only to contracts of carriage covered by a bill of lading or any similar document of title. Pause there. So it's a bill of lading convention, and there are specific provisions which say that it is not applicable to charter parties, Article 5, and it's not applicable to special cargoes carried under special non-negotiable receipts, Article 6. So it applies to bills of lading insofar as such document relates to the carriage of goods by sea. Pause there, my Lord, as I'll show the court in a moment. Bills of lading can cover not just sea carriage, but inland carriage as well. So in our submission, what this is focusing on is a contract in a bill of lading, so long as the bill, or at least insofar as that bill of lading is regulating a sea carriage, not a land carriage, or something like that. And then it also applies to any bill of lading or similar document as aforesaid issued under a charter party from the moment at which such instrument regulates the relations between a carrier and a holder. So that's dealing with the situation where the bill of lading is effectively a receipt under a charter party and then becomes the operative contract itself. The situation recently considered by the Court of Appeal in the Siena. And then E, carriage of goods covers the period from the time when the goods are loaded on to the time they are discharged from the ship. Now, both of those definitions were considered by Mr. Justice Devlin in Irene and Cynthia, and I'll take the court to that now. But again, in relation to 1E, however widely one construes 1E, the argument put against the respondents is that loading and discharge are the cut-off points, or the start point and the cut-off points. So I've already taken the court to the OT Sonia and the Sophie J. Those cases have to be reconciled with that argument. In our submission, it's not easy to do so. But if I now take the court to Pyrene and Cynthia, it's in the core volume at relevant pages, starting at page 822. And you were taken to part of this this morning by Mr. Smith. The argument for Mr. McGaw was that the truck wasn't covered by the rules, so they couldn't limit liability because it wasn't across the rail. And Mr. Justice Devlin said this. So he sets out Article 1B, which we've just been looking at, top of page 823. In my judgment, this argument is fallacious. The cause of the fallacy perhaps lying in the supposition inherent in it that the rights and liabilities under rules attach to a period of time. I think they attach to a contract or part of a contract. Well, that's not really consistent with the strict temporal approach in our submission, and one sees why Mr. Justice Devlin puts it in that way. I say part of a contract because a single contract may cover both inland and sea transport. In that case, the only part of it that falls within the rules is that which, to use the words in the definition of contract of carriage in Article 1B, relates to, my Lord Sales, those are the words that came up in the OT Sonia, relates to the carriage of goods by sea. Even if carriage of goods by sea were given by definition the most restricted meaning possible, for example, the period of the voyage, the loading of the goods, by which I mean the whole operation of loading, in both its stages and whichever side of the ship's rail, would still relate to the carriage on the voyage and so be within the contract of carriage. And then he goes over, at the bottom of that paragraph, he starts a new paragraph. Article 2 is the crucial article which for this purpose has to be construed. And that's precisely the issue on this appeal. It's this article that gives the carrier all his rights and immunities, including the right to limit his liability. He's entitled to do that in relation to the loading and under every contract of carriage. And then he goes on to consider what the meaning of loading in Article 2 is, which we're not concerned. But if you go over to page 824, and in the middle of the main paragraph, the obligations in Article 3, Rule 1, for example, to use due diligence to make the ship seaworthy and man and equip her properly are independent of time. The operation of the rules is determined by the limits of the contract of carriage by sea and not by any limits of time. The function of Article 1 is, I think, only to assist in the definition of contract of carriage. As I've already pointed out, there is excluded from that definition any part of a larger contract which relates, for example, to inland transport. It is natural to divide such a contract into periods, a period of inland transport followed perhaps by a period of sea transport, and then again by a period of inland transport. Discharging from rail at the port of loading may fall into the first period, loading onto the ship into the second. The reference is to when the goods are loaded on in Article 1E is not, I think, intended to do more than identify the first operation in the series which constitute the carriage of goods by sea, as when they are discharged denotes the last. So, my Lord...
Isn't all this just saying that there's not a sort of cut-off at the ship's rail at each end, but it's the whole operation of loading and discharge that is included?
Yes, but he's also saying that the definition in Article 1B is referring to the, as it were, the sea carriage part of the operation carried out in the bill, not the inland part.
I understand that, but it's 1E that's particularly important for present purposes, isn't it?
It is, my Lord, yes.
But I don't see how you get around the fact that 1E confines the carriage of goods to starting with loading and ending with discharge.
My Lord, I entirely accept that.
Yes. Well, then that comes into Article 2.
Well, then one has to look at Article 2. And if we go back to the text of the Convention, which is at core volume page 1233, subject to the provisions of Article 6, which is a special provision which allows one to issue non-negotiable receipts in relation to special cargoes. Under every contract of carriage of goods by sea, the carrier, in relation to the loading, handling, stowage, carriage, custody, care and discharge of such goods, shall be subject to the responsibilities and liabilities and entitled to the rights and immunities hereinafter set forth. Now, my Lord, it is in our submission relevant to have in mind the French text for this provision, the French text being the only authoritative text of the Hague Rules. So if we turn back to page 1232, we have le transporteur sera, and then it lists the various operations, soumis aux responsabilités et obligations. So instead of responsibilities and liabilities, it's responsibilities or responsabilités et obligations. Comme il bénéficiera des droits et en exonération ci-dessous énoncés, as he will benefit from the rights and exemptions set out below. So the only way one finds the restriction of Article 3, Rule 6 is in this provision.
So what do you get from the French text that we don't get from the English text?
My Lord, it's simply the use of the word liabilities rather than obligations, and the use of the word...
Right, just where are we?
So the English text says responsibilities and liabilities.
Well, is obligation a synonym for obligation in English? I mean, it's translated here as liabilities. Are you saying that's the wrong translation?
Well, I'm saying that if we want to get at what it's actually dealing with, it's dealing with obligations.
Dealing with obligation?
It's dealing with...
I mean, I don't know. I mean, you're asserting that obligation has a slightly different meaning to liabilities, as I understand it.
It's not
I
necessary.
mean, I agree as a matter of English, obligations is wider than liabilities, or can be. But I just don't know whether that's true in French.
I mean, have you a submission as to the scope of the word obligation in French?
My Lord, my submission is that it means obligation.
Why is it translated as liability?
Well, my Lord, and similarly, the exonération is translated in French, is usually translated in French, CR dictionary extracts, as exemption,
Okay.
and it is here translated as immunities.
What is the general point that you're taking from this?
My Lord, the point I'm taking from this is we're trying to see what it is that is being identified in Article 2.
Right.
Because if it's obligations, then the pre-loading obligations in Article 3(1) and so on, you would say, show that there isn't the tight temporal restriction.
Well, Lord, I wouldn't put it quite like that.
No.
I think
Perhaps I'm saying too much.
I think what we're saying is, what is it that Article 2 is providing for? Which provisions in this convention is it actually directed at? And we can see from the text, whether in English or in French, it's saying the carrier shall be subject to responsibilities and liabilities.
Yes.
Or responsibilities et obligation, it doesn't matter.
Yes.
So the first question is, if we're looking at that part of Article 2, is Article 3, Rule 6, and the time bar a responsibility and liability?
Well, it is. That responsibility is what the French text says in Article 3, Rule 6, isn't it? Shall not be responsible.
Yes, my Lord, but we're dealing with shall be subject to a responsibility and a liability. So is it, as a matter of construction of the treaty, a legitimate reading to say the carrier shall be subject to the time bar in Article 3, Rule 6?
I would have thought so.
I'm sure you have to read the time bar with what it's barring, don't you? You don't read it on its own, if you're asking this question.
Well, my Lord,
Because the point about the time bar, as Lord Wilberforce said, is to extinguish the liability, at any rate.
well, my
So it's
Lord,
I mean, it could be said, couldn't it, that it's part and parcel of the responsibility and liability.
well, my Lord, we would submit that what Article 2 is providing for is that it's saying that there are certain responsibilities and liabilities or obligations which the carrier will be subject to. It says the word shall be subject to.
Yes.
And it is wrong as a matter of language, we would submit, to say that he is subject to a time bar provision. Because
He's subject
That
to
may be so, but he's subject to certain responsibilities which you then see. And then when you get to the time bar provision, he's discharged to toute responsabilité. So he's discharged from those responsibilities.
But it's not something to which he's made subject, my Lord.
Well, why does that matter?
Because the operative words of Article 2 are providing for responsibilities and liabilities to which the carrier is made subject, which he therefore he has to carry out, and then to rights and immunities to which he is then entitled. In our submission, if we take them in stages, Article 2 is when it provides that the carrier shall be subject to certain responsibilities and liabilities. It is wrong as a matter of language to construe that to say he is being subject to the time bar. You're reading, you have to now go ahead and find where are the responsibilities and liabilities to which he is being made expressly subject. And we find at least two in Article 3, namely the obligation under Article 3, Rule 1 to make the ship seaworthy, and the obligation in Article 3, Rule 2 to take proper care of the goods. And so one sees, we would submit, the concept of responsibilities and liabilities, or obligation, it doesn't matter ultimately, one sees that the Article 2 is saying that in relation to these specific operations, loading, etc., the carrier is going to be made subject to certain responsibilities and liabilities. And in our submission, what that is saying, as a matter of ordinary language, in accordance with context and purpose, which I'll come on to, is saying that the carrier, in relation to these operations, will owe the following obligations.
And their rules 1, 2, and 3, are they?
They're rules 1, 2, and 3, my lord, yes.
Yeah.
And indeed, when one looks at Article 3, Article 3, Rule 1, one sees that Articles 1 and 2 are specifically related to loading, handling, stowage, carriage, custody, care, and discharge. Article 3, Rule 2 actually uses the same words. Article 3, Rule 1 is the obligation to put the ship in a proper condition to be able to load, handle, stow, carry, and have proper care of the goods in a good condition, a seaworthy condition. So in our submission, if one's just trying to construe Article 2, which is an exercise the Court of Appeal did not conduct, the critical question is the Article 3, Rule 6 time bar a responsibility or a liability to which the carrier is made subject? And in our submission, it's a very short point of construction, in our submission it is not. The next question is whether the provision that in relation to those operations it will be entitled to the rights and immunities set out, whether that applies to the Article 3, Rule 6 time bar. And in our submission, it doesn't, because the time bar, those words are naturally directed at Article 4, which sets out certain mandatory exemptions, exonération, and certain specific rights, deviation, the right to deal with dangerous goods. And if one looks at Article 3 and Article 4 together, one sees the linking up of the responsibilities and the liabilities in 3, Article 3, and the exemptions and rights in Article 4. It's expressed in Article 3.2, subject to the provisions of Article 4, the carrier shall, etc. It's expressed in Article 4, Rule 1, which provides that for an exemption, an exception to the duty under Article 3, Rule 1. So it says neither the carrier, etc.
Right.
So I'm on Article
4. What was the first point you made about Article 3? I'm sorry.
Article 3.2, my lord.
3.2. I see.
Specifically refers
Yes,
to
I
Article
see.
4. So the key obligation to care for the goods is made subject to Article 4.
Yes.
And the key obligation to make the vessel seaworthy is subject to the exception in Article 4.1, which expressly refers back to paragraph 1 of Article 3. So what one has are two interlinked sets of provisions which are dealing with imposed duties, principally 3.1 and 3.2, and the exceptions to those, principally 4.1 and 4.2, together with a bundle of additional rights in relation to the goods during their carriage. For example, dangerous goods can be offloaded, and the vessel may deviate. And in our submission, that is the correct reading of Article 2, and it is not, in our submission, dealing with the discharge of liability or the notice of claim provisions in Article 3, Rule 6. And that makes a perfectly coherent whole, because then the period of responsibility is properly defined in this way. that in relation to certain specified operations, as listed in Article 2, which you might regard as a period, but is a set of operations starting with one and ending with the last, the carrier is subjected to, made subject to, certain specific obligations and duties, and is entitled to certain specified exemptions or exclusions and certain specified rights. And in our submission, again, it is really a very short point. In our submission, that does not include the Article 3, Rule 6 time bar, which is worded extremely widely and therefore doesn't naturally fit into that period of responsibility. The period of responsibility is simply creating an irreducible minimum of obligations with their qualifications. And that was the purpose and the context, because, as my learned friend read out this morning, there were a number of mischiefs which the Hague Rules set out to deal with. One mischief was that the carrier accepted virtually no obligations at all. Had a very, very long list of exceptions to his obligations. That is what in our submission Article 2 is dealing with, to create an irreducible minimum of obligations with specified exemptions and qualifications. The other mischief were notice of claim provisions and time bar provisions, and that was what Article 3, Rule 6 dealt with in the terms in which it dealt with. But in our submission as a matter of construction, Article 2 will only apply to Article 3, Rule 6 if it can be construed, or if the terms used in it about responsibilities and liabilities and rights and immunities can be construed as referring to or including Article 3, Rule 6. If it can't, then the period of responsibility argument collapses. And that really is the short point for this court.
I mean, as a matter of ordinary language, accepting that the word immunities is probably not the word we might choose today rather than in 1924 or whenever, why would that not include a time bar?
My Lord, as a matter of language on its own, I can see that it might.
Because after all, you start with Article 3.6 with its language on its own. That's your starting point. So,
my Lord, we say it doesn't here,
yes,
because
in the context it doesn't.
In the context, and you get confirmation from that from the French text, because the French text is saying it is exonération, which it means exemption. So what three?
Not extinguishment.
Not an extinction of liability, no.
A fine distinction.
Well, my Lord, what one's reading, when I was reading Article 2, one has to read the use of these terms together and see what they were actually trying to arrive at.
Yeah.
They're saying, look, in relation to these specific operations, loading to discharge, you're subject to these obligations, responsibilities and liabilities, and you're entitled, in relation to those self-same operations, to these rights and these immunities, exonération, exemptions. So we would submit that putting those two together, and the way it's used specifically in relation to the specified operations, one sees precisely what the drafters have achieved. An irreducible minimum of obligations and an irreducible maximum of qualifications to those obligations. And it really depends whether this court construes responsibilities and rights and immunities which are used in union with each other as dealing with Article 3, Rule 1, Rule 2 and Article 4, or as being intended to be wider. And we would submit that given the language of Article 2, both in the use of the specific operations, then in the reference to responsibilities and liabilities which follow, which are specifically linked to those specific operations, and then to the rights and immunities which are specifically linked to those obligations, one has a coherent whole which sets out an irreducible minimum of obligation, but which doesn't touch or address Article 3, Rule 6.
Well, it's an irreducible minimum. Is it because of Rule 8? It says that you can't cut down those obligations.
My Lord, I'm now going to come to Article 7 and Article 3, Rule 8.
Right.
So if we
Because then Article 8 is subject to accept as provided in this convention, and then Rule 6, sorry, I meant Rule 8. Rule 8 says you can't cut it down, but that's subject to, says, provided in this convention, and Rule 6 brings back in, as it were, the opportunity to discharge from liability after a year.
So, my Lord, if we go to Article 7 first.
Yeah, Article 7, right?
Yeah, which is dependent, as it were, to Article 2. Possibly picking up first Article 6, which is what Article 2 says it's subject to. Article 6 allows special contracts. Liberty to enter into any agreement in any terms as to the responsibility and liability of the carrier for special goods, and as to the rights and immunities of the carrier in respect of such goods, or concerning his obligation as to seaworthiness, so far as the stipulation is not contrary to public policy, or concerning the care and diligence of his servants or agents in regard to the loading, handling, stowage, carriage, custody, care and discharge of the goods, provided that no bill of lading is issued. So that's a specific exception to Article 2. And then Article 7, nothing herein contains to prevent a carrier or a shipper from entering into any agreement, stipulation, condition, reservation or exemption as to the responsibility and liability of the carrier or the ship, loss of or damage to or in connection with the custody and care and handling of goods prior to the loading on and subsequent to the discharge from the ship on which the goods are carried by sea. So Article 7 allows you to make different provisions from those in Article 2 for operations which are cargo operations, but which are not those listed in Article 2. And if we then go back to Article 3, Rule 8, which is at page 1235, any clause, covenant or agreement in the contract of carriage relieving the carrier or ship from liability for loss or damage to or in connection with goods arising from negligence, etc., in the duties and obligations provided in this article. So that's Article 3, Rule 1 and Article 3, Rule 2, or lessening such liability otherwise than provided in this convention shall be null and void and of no effect. And it's, it would be our submission that those words mean that the separate package, which is in Article 3, Rule 8, Article 3, Rule 6, is not capable of being contracted out of, because the carrier has undertaken by these rules that the discharge of liability for all liability under the bill of lading contract shall be 1 year and no less than 1 year. And so if Article 3, Rule 6, the time bar, is not linked to the period of responsibility, which we say it is not, it is a freestanding provision of this convention applying to the bill of lading contract.
Well, isn't suppose the carrier puts in a 3-month time limit, then that will be on its obligations, on liability for all the things set out in Article 3, Rules 1 and 2. Then that will be void under Article Rule 8, won't it? It can't be effective.
Correct, my Lord.
However, one can't apply that to the 1-year limit because of the words as provided in this convention, which is allowing the carrier to have the cut-off at a year.
Yes,
which is in Rule 6. Doesn't it all fit together? in that way?
That's there are two alternative readings.
Right.
Either you can't lessen your liability at all, or you can lessen your liability even in relation to the time bar for operations which fall outside loading and discharge. And I take your Lordship's point that the words otherwise and as provided for in this convention arguably would allow the carrier to say that I'm contracting out of my 1 year time bar in relation to operations on either end. But that doesn't tell you whether the Article 3 Rule 6 time bar is only to apply during the period of responsibility. Because, again, we come back to the need to find that the Article 3 Rule 6 time bar is either a responsibility, a liability, a right or immunity, as actually referred to in Article 2, and we submit that it is not.
So just to be clear, if the carrier made provision, as my Lord has said, for a 3-month time bar in respect of any loss or damage occurring between discharge and delivery, you accept that that would be valid, not void?
My Lord, I would.
Yes. Okay. Thank you.
My Lord, we now have to turn on to the explanations and statement of the structure and scheme of the Hague Rules given in various cases and commentaries which in our submission supports our argument that Article 3 Rule 6 time bar is not within the scope of Article 2, and that Article 2 is dealing with different matters. And if I can take the court to the recent decision of this court in the CMA CGM Libra, which is in the core volume at page 422. This was the case about whether passage plans or defective passage plans at the beginning of a voyage would make the vessel unseaworthy. And it was a Hague Rules case. And if I can just ask the court to turn, please, to page 439. Starting actually at page 438. The interpretation of the Hague Rules. The starting point is the ordinary meaning of the wording of the relevant rules in the context of the Hague Rules as a whole. And over the page at page 439, the scheme of the relevant rules is clear, as foreshadowed by Article 2. Article 3 sets out the responsibilities and liabilities of the carrier, and Article 4 sets out the rights and immunities of the carrier, and we would endorse that. The carrier's primary responsibilities under Article 3 are, before and at the beginning of the voyage, to exercise due diligence to make the vessel seaworthy and properly and carefully to care for the goods. In relation to the obligation of seaworthiness, the relevant right and immunity of the carrier set out in Article 4, Rule 1, which defines the circumstances in which the carrier shall not be liable. In relation to the obligation to properly and carefully care for the cargo, the relevant rights and immunities are set out in Article 4, Rule 2, which provides a list of general exceptions. The entirely different regimes governing the paragraph 65, the carrier's responsibility for negligence under Article 4, Rule 1 and Article 4, Rule 2 confirms what is apparent from the scheme of the Hague Rules, namely that Article 4, Rule 1 sets out the relevant right and immunity for the carrier's responsibilities and liabilities under Article 3, Rule 1, And Article 4, Rule 2 sets out the relevant rights and immunities for the carrier's responsibilities and liabilities under Article 3, Rule 2. And we submit that is an entirely correct reading of Articles 2, 3 and 4 together. And is a reading which, as this court pointed out in paragraph 66 and following, was stated by the Privy Council in the Maxine footwear case. And that understanding, in our submission, is supported by the textbooks. I can ask the court to go to core volume at page 1432. This was the first edition of Carver following the introduction of the Hague Rules, the 7th edition, 1925. And if I can take the court to page 1434. At the top of that page, the paragraph starting that Act. That Act has wide application, certain exceptions of limited scope. Its effect is to introduce into all bills of lading issued in this country certain standard clauses defining the risks to be assumed by sea carriers for the period of the voyage and defining also certain rights and immunities which sea carriers may enjoy. The risks, responsibilities and liabilities to be undertaken by sea carriers are absolute and irreducible. As set out in the rules schedule to the Act, they become by law part of the terms of the contracts for the carriage of goods by sea, evidenced by bills of lading. The rights and immunities of sea carriers under the Act, on the other hand, may be surrendered in whole or in part by a clause embodied in the bill of lading. As a consequence of these statutory liabilities of ship owners being made irreducible, the interests of endorsees of bills of lading who are not parties to the contract for the carriage of goods by sea are protected. And then if we go down to the bottom of that page, in all other cases, the sea carrier's minimum liability is imported into the contract by being made compulsorily made part of the terms of the bill of lading, which is evidence of the contract, are in outline as follows. And then carriage of goods. The carrier is bound to exercise due diligence to provide a seaworthy ship. The carrier must properly and carefully load, and then it refers to the bill of lading provisions. Any clause which would relieve the carrier or the ship from these and some subsidiary liabilities set out in the rules scheduled to the Act will be of no effect. Though subjected to these statutory liabilities which are irreducible, the carrier is given certain rights and immunities, which, however, he is at liberty to surrender in whole or in part by a clause embodied in the Bill of Lading, Article 5. The statutory exceptions thus set to the statutory liabilities comprise exemption from liability for loss or damage, 1, resulting from unseaworthiness provided due diligence has been exercised, it's Article 4, Rule 1, resulting from a series of accepted perils set out in Article 4, Rule 2, resulting from deviation in saving or attempting to save life, Article 4, Rule 4, and the package limitation. So what one has there is this recognition in our submission of what the court explained in the CMA CGM Libra, that the responsibilities and liabilities, the obligations, the minimum set of obligations, are those obligations set out in Article 3, and the exemptions to those obligations are those set out in Article 4. And that remained the text of Carver down to the last edition before the Hague-Visby rules came in, and we've made reference to those in our written case, but they start at page 1436 in the bundle or volume and page 1442. is then if we look at Scrutton on charter parties,
So that was the 12th edition.
that was the 12th edition, my lord. There's the 7th edition, and then we have in the bundle the 10th edition, which was the one which Mr. Collinvoe took over in 1957, and then the 12th edition in 1971.
Yes, thank you.
And then in the last few minutes which remain, if I can just take the court to Scrutton on charter parties, the first edition after the Hague Rules, which is at the core volume at page 1483. This was the first edition after the Hague Rules when Sir Thomas Scrutton ceased to be the editor because he considered that he might have to express views on the Hague Rules which he was very opposed to, and some other editors took over, Mr. Porter and Mr. McNair, as they then were. So this is 1925, and over the page at page 1484, the general scheme of the rules is as follows. Article 2 provides that in every contract of carriage of goods as defined in Article 1, with the exception of certain special shipments dealt with in Article 6, the carrier shall be subject to the responsibilities and liabilities contained in Article 3 and entitled to the rights and immunities contained in Article 4. These articles appear to impose on the carrier certain minimum responsibilities which he cannot reduce, e.g. to exercise due diligence to provide a seaworthy ship, to load, handle, stow, carry, keep careful and discharge the goods, and to issue a bill of lading in a particular form, and to throw upon the carrier the liability for the proper and careful conduct of these operations while giving him certain maximum exemptions which he cannot increase. And then the current edition of Scrutton is at page 1488. And in the core volume, the various editions between that and the current are included. But at 1498, we have the 25th edition. And if I can take the court, page 1500. The scheme of the rules is explained in terms similar to those we've seen in Carver and in the earlier edition of Scrutton on charter parties. The general scheme of the rules is as follows. Article 2 provides in every contract of carriage of goods as defined in Article 1, with the exception of certain special shipments, the carrier shall be subject to the responsibilities and liabilities contained in Article 3 and entitled to the rights and immunities contained in Articles 4 and 4 bis. The articles impose on the carrier certain minimum responsibilities which he cannot reduce, seaworthy ship, bill of lading in a particular form. Responsibility for performing other operations may be divided between the carrier and the shipper in whatever manner the parties may wish, provided that no term will be effective if it is inconsistent with the main object and intention of the particular bargain. Insofar as the carrier does undertake to carry out the operations, he must do so properly and carefully. The articles confer on the carrier certain maximum exceptions which he cannot increase. The defences and limits of liability provided for in the articles apply only to the carrier himself, but also to servants and agents.
Is the 1 year time limit an immunity which can be surrendered under Article 5 if the carrier chooses?
My Lord, we would say no. And I'm conscious I'm going back in a different direction to a question my Lord Richard.
I know.
But perhaps I can come back to that tomorrow.
Yes.
It is 4 o'clock.
Would that be a convenient place to adjourn?
Yes, Lord, thank you very much.